about present concept of marriage. Under the old Hindu law, marriage was seen as a sacrament, a sacred, lifelong bond that could not be broken. But after this act, that is Hindu Marriage Act, 1955, things changed. For the first time, the law introduced divorce under sections 13 and 13b. This means a marriage can legally end if certain conditions are met, and both husband and wife can remarry if they wish. This includes remarriage of widows and widowers, which earlier faced social restrictions. Because of these changes, the purely sacramental character of Hindu marriage was reduced. It is no longer an unbreakable bond for life. However, Hindu marriage has not become a full legal contract either. In a normal contract, there are certain requirements like offer, acceptance, consideration, and complete freedom to agree or disagree. These requirements are not all present in a Hindu marriage. So, today, Hindu marriage is a mix. It is still a sacred relationship with religious importance, but it also has legal recognition and legal ways to end it. Now let's look at the 5 main conditions for a valid Hindu marriage under Section 5 of the Hindu Marriage Act, 1955. First, monogamy. Second, soundness of mind. Third, age of marriage. Fourth, beyond prohibited degrees. And finally, beyond Sapinda relationship. All these conditions must be followed for the marriage to be valid under the law. The first condition for a valid Hindu marriage under Section 5(1) is monogamy, meaning only one spouse at a time. If a person gets married again while their first spouse is still alive and the marriage has not been legally ended, that second marriage will be against the law and void. However, there are situations where a person is legally free to marry again. If they have obtained a decree of nullity under Section 12, which means the first marriage was declared invalid from the start. If they have obtained a decree of divorce under Section 13 or 13b, which legally ends the first marriage. If their spouse has been unheard of for at least 7 years by people who would normally know about them, the law presumes that spouse is dead. In that case, they can remarry. If the first marriage was not solemnized properly according to the law or rituals, the second marriage will be valid. In a case, Yamunabai Anantrawada versus Anantrawtararamada. The Supreme Court has made it very clear about the first condition of Section 5, which is monogamy. If this condition is not followed, that is if someone marries again while their first marriage is still valid, then the second marriage is null and void. The court also said that if a marriage is void, the wife from that marriage cannot claim maintenance under Section 125 of the Criminal Procedure Code. This is because, in the eyes of the law, she was never a legally wedded wife. The second condition for a valid Hindu marriage under Section 5 subsection 2 is about soundness of mind. At the time of marriage, bride and groom should not fall into these categories. First, they should not be incapable of giving valid consent because of unsoundness of mind. If a person cannot understand what marriage means, they cannot legally marry. Second, even if they can give consent, they should not be suffering from a mental disorder that makes them unfit for married life or for having children. Third, they should not have recurrent attacks of insanity or epilepsy. The idea behind this condition is to make sure both partners are mentally fit to understand the responsibilities of marriage and to live a normal married life. If this condition is not met, the marriage is voidable. This means the other spouse can go to court and get it annulled under Section 12 of the Act. In the case of Anima Roy v. Prabhat Mohan Roy, the court explained what mental disorder means for marriage purposes. The court said that just being mentally ill is not enough to cancel or avoid a marriage. The illness must be so serious that living together as husband and wife becomes meaningless or impossible. So, the law doesn't end a marriage for minor mental health issues. It only applies when the condition truly stops the couple from having a normal married life. The third condition for a valid Hindu marriage is about minimum age. Under the Child Marriage Restraint Amendment Act, 1978, the law fixed the minimum age for marriage at 21 years for the groom and 18 years for the bride. Later, the Prohibition of Child Marriage Act, 2006 made stricter rules to prevent child marriages. First, it prohibits the solemnization of a child marriage. Under Section 3, if a child marriage does happen, it is voidable, meaning the person who was a minor at the time can go to court and cancel the marriage. But they must file this petition within 2 years of becoming an adult. Section 13 gives power to a judicial magistrate of the first class or a metropolitan magistrate to issue an injunction order to stop a child marriage before it happens. Section 14 says that if a child marriage takes place despite such an injunction order, it will be void from the beginning, or void ab initio. Related. The law calls these prohibited degrees. It explains whom you can't marry. Lineal descendants, that is direct ancestors above you, that is your parents, grandparents, or anyone who is a direct ancestor. Wife or husband of lineal descendant or descendant of the other, that is someone who was married to your father, son, grandfather, or similar. Your brother's wife, your uncle's wife, or your grandfather's brother's wife. Your own brother or sister, uncle and niece, aunt and nephew, or first cousins if they are the children of your brother and sister. Now, there are some extra points about prohibited relationships. First, this rule applies not just to full-blood relations, like same mother and same father, but also to half-blood relations. That means even if you share only one parent, the restriction still applies. Second, it applies to illegitimate relationships as well as legitimate ones. So even if the parents were not married when the child was born, the relationship still counts under this rule. Third, it applies to adopted relationships too. So if you're adopted, your adoptive parents and relatives are treated the same as blood relatives for this purpose. The last condition for a valid Hindu marriage is that the boy and girl must be beyond the Sapinda relationship. The word Sapinda means of the same pinda, in simple words, from the same bloodline. The rule is, on the mother's side, you can't marry if you are related within 3 generations. On the father's side, you can't marry if you are related within 5 generations. Let's picture this with a simple example. Think of yourself as generation 1. On your mother's side, count upwards. Your mother is generation 2, your grandmother is generation 3, your great-grandmother is generation 4. If someone shares these close generations with you, marriage is not allowed. On your father's side, it's a bit longer. Your father is generation 2, your grandfather is generation 3, your great-grandfather is generation 4, and your great-great-grandfather is generation 5. Anyone related within these limits is still considered Sapinda and you can't marry them. The only exception is if there's a valid custom in your community that allows such a marriage.